because two of his teachers have collaborated and come up with this project where the students are going to be attending a series of musical theater productions that are going to be put on over the course of the school year. And he has found that when venue where they hold these performances, he has a really hard time understanding what's going on. And so he has complained, and his parents have complained about his being required to participate in this particular project. So, which laws, if any, provide us some guidance in what should happen in this scenario, and ideally, what should happen? So, what did you guys decide?
We decided on two of the laws, but specifically ADA, we were talking about, like, so the venue was like a major part of
Okay.
that. So it said it's designed to promote equal access to participation in programs and services. So clearly, if he's actually like participating and like being like in the audience, he should be able to get the same thing.
Okay, so I totally agree. ADA does offer him some protection. And ADA does specifically address communication, good hearing. So what might be a solution under ADA to address this problem?
You're thinking that they could give him a script of the play or something before so that if he can hear some of it but follow along, that would
Okay,
help.
so having a script, right, that might be very helpful. What else though?
We also talked about assistive listening devices.
Absolutely. There is a huge initiative going on across the country to loop public venues so that anyone with a hearing loss and has a telecoil option on their hearing aids would be able to have access to the sound so that he would be basically directly tapped into the sound system in the venue. So yes, that is one solution, and probably the easiest solution is, what about idea? Does it, or could it potentially come in any way?
We thought that it could, where they could like offer him an alternate assignment.
Okay, right, yeah, maybe he's got a curriculum modification, or if he doesn't, perhaps his parents can request one. Problem is, unless there's, and correct me ladies in the back if I'm wrong, unless there's some specific change in status, the school's not obligated to update his IEP until the annual. Is that correct?
If they're gonna make a formal addendum or an amendment,
Okay,
then
okay.
I
So,
think they have to be.
but, so the parents can request it,
At any time.
right, but the school's not necessarily obligated unless there's some sort of a change in status. Am I right with that?
Right, like if it, well, yeah.
Because his hearing hasn't changed. So unless there's something in there about curriculum modifications that would cover this, they can request it, but they may not get it. But yes, absolutely, an alternate assignment would be a great alternative. What else might they do?
With preferential seating, being in the front row, or just depending
Somewhere,
on the
yeah.
acoustics
Okay.
are like the best for him to
Right,
see.
right, so they could offer him preferential seating, absolutely. What's another possible?
Is it like an interpreter too, like timing?
Yes, if he knows sign, they could provide an interpreter. What if he doesn't know sign? He's in the 6th grade though. might they be able to provide?
Like an aid for taking notes or something?
They possibly, but I'm thinking of something technology-wise
I
that,
don't know what they're called, but it like writes out the script.
yeah, a teleprompter that
Yeah.
has like the captions what is being said. Yeah. And what's really cool is there's an app called Dragon Communication where you basically talk into it and so, you know, if they and it's free. It's free. So if they have, you know, any kind of a tablet computer in the school, they could download that app, he can take it with him, and it's gonna pick up hopefully the sound of what's being said and real time presented on the screen. So yes, so I think the key for this kid is we need to tap into the potential technology that's available. He definitely has some recourse under ADA, and that's probably the easiest, depending on what's in his IEP, or how willing the school is to adapt or offer an addendum or an amendment to it. He may or may not have a whole lot of recourse under IDEA. What about 504? Anything there that would cover it? I mean, they do get federal money, so technically it could apply, but do you see any ways that if the parents request, you know, they could request any of the things that we've talked about, and they may or may not get it. So this is one where really all three laws could apply, but I think that probably the one that they'd have the most success with, because it's very specifically stated, would be ADA. Any comments, questions, other ideas? Okay, good job. All right, case number 2. Case number 2 is about Eva, and she's a high school student with a severe to profound hearing loss. So basically, she's in that 70 dB and worse. She's mainstream and she uses binaural amplification. Even with her hearing aids, though, her speech discrimination scores are not very good, and so she still relies on a lot of visual cues in order to pick up on what's going on. Frequently in class, they're using multimedia, things like videos, movies, things like that. And she is really feeling like she's missing out on a lot because she can't understand a lot of what's being said. And so she's specifically requested that captioning be provided during those activities. But the teacher's balking at that and says that not all the materials that we have are captioned, and it would really cost us too much money to buy versions that are captioned, and besides, for the people who don't need them, those captions can be really distracting. So, what laws might apply in this scenario, and ideally what should happen?
We said we actually said the 3 laws applied, ADA is the best probably, which also providing assistive technology, systematically captioning. It's not that big of a deal, honestly, for even providing good captioning teachers to kind of be injured. But and then the school can pay for the videos they don't have, and if they're going to be back and she can't use the videos, it doesn't have caption.
Okay. I would definitely agree this is another situation where there's pretty quick and easy fix for and using technology. And again, ADA definitely specifically addresses this. What about any of the other laws? And see how they might apply.
Special education services that are IDEA. Special education services that are IDEA. I'm not sure if actually this is there in special education services or not, so if not, like, identify the scope and it's just say something.
But, think about the discussion we just had with a kiddo who needed help hearing and understanding in the auditorium. I think the same types of arguments or the same types of scenarios might apply. What does her IEP say? You know, maybe they get an amendment to specifically state that any audio visuals captioning is to be provided. If it's not already addressed, maybe because her hearing loss is severe or profound, there's an increased likelihood that she might sign. So again, providing an interpreter. I think we can use a lot of the same discussion and arguments that we use for Cameron's case. I think would apply here. Do you agree? No? You see kind of connections. It's a similar complaint. I can't hear what's being presented. Just the venue is a little bit different, and the options are a little different. We have one that's live, whereas the other is recorded. It wouldn't necessarily be that difficult to provide the necessary services. So I think we could make an argument that all three laws have something to offer. But again, in this case, ADA probably provides the easiest solution or path to a solution. Any weight? Any questions? How? Is there any question in either of these cases that IDEA would apply because what are the criteria for eligibility for an IEP related to hearing loss? Do they have a qualifying condition? And what's the requirement for hearing loss to be a qualifying condition under IDEA? They have to have return averages in excess of 25 dB. Obviously, they go to it, one's a moderate to severe and one's severe to profound. If we think back to what are the decibel levels that correspond to those severities, obviously they do. Do you think that there's evidence based on the scenarios that there's an educational impact going on here? Yeah, I think it's pretty obvious. If they don't have access to the auditory information, then there's obviously an educational impact there. So they should not only have a qualifying condition, but they should pass the benchmark for eligibility. So remember, just because you have the condition doesn't mean you're eligible. I think that we have evidence. Yes.
Is this the kind of question that we might have on the exam then? Like a case?
This would be very similar.
Would you want us to provide like possible like all three could apply, or would you rather us focus on
I think
one that?
I think in a scenario like these two, I think you might say that, you know, this would apply for this reason, this would apply for this reason. However, I think this is the one that's probably most likely to give that, like we just did, because we can make a case for all of them. But I think clearly in both of these cases, we have a pretty easy technology solution, and ADA specifically addresses that. So, and it's not an unreasonable. Now remember, one of the key things about ADA is that it has to be what's considered a quote-unquote reasonable accommodation. But is it reasonable to expect captioning for that type? I would say yes. You know why I would say yes? Federal law requires all TVs that are manufactured in the United States since I think the last 8 to 10 years must have captioning available. I'm waiting. I think the day is coming very soon, very, very soon, where they're also going to make SAP available, mandatory as well. And that's the, you might see stop. And it'll caption it in Spanish for you. And I have a feeling that it's not going to be too long before that's going to be required. Because it used to be you had to pay extra, you had to buy a caption box and attach it to your TV, and then it would caption things. But now all TVs have to be manufactured with that. Well, right now you have to have a special little plug-in for the Spanish subtitles, but I think that it's not going to be long where they're probably going to make that mandatory as well. And I'm not arguing for or against it, I can see that I think we're moving in that direction. And I think once we have our 51st state, they're going to kind of have to, because we're going to have 5.5 billion people, and most of them Spanish is their first language. Okay. All right. Case number 3. This is one of my favorites, and there's a lot going on in this one. Amy is 5 years old, and she lives in a rural area on a Native American Indian reservation with very limited access to specialty care. The state does not have any mandatory hearing screening or follow-ups for newborns, but she did have when she referred on it. And she had 2 subsequent rescreens, and she referred on those. But because there's no required follow-up, and because there's such limited access to services, nothing happened. So now she's in school, she's in a local public school on the reservation, and she's receiving speech therapy. She has multiple articulation problems. SLP says she's hard to understand, she's loud, she's somewhat hypernasal. She's had a lot of ear infections and had PE tubes. And her mom's really frustrated because she doesn't see that Amy's really progressing, getting any better. So mom has requested that the school do a hearing test, but they don't have an audiologist on staff. They only have a screener. And she passed the middle ear screening, so no evidence that she's got fluid issues going on now, but she failed, for all intents and purposes, the pure tone screening, and they were getting responses in the 35 to 45 dB range, so in the mild, approaching moderate range. The closest audiologist is 150 miles away, and the family has no car to get there. So what should happen next? What laws provide mom and or the school with direction as to what should happen? Ladies, take it away.
We thought that RTI applied just because she wasn't showing progress with her intervention.
Okay.
And then but they also needed to request, well, like, we were talking about transportation, but it was kind of iffy whether they provided or not, so we had to wait to see if they would either bring an audiologist in or give them services so she can see them.
Let's back up a little bit and dissect this. You guys have a really complex case. Okay. what's the purpose of RTI? Right, so we wanna see if we can avoid the use of special services, right? The need for it, and yet she's already receiving it. So that we may try some specific things to improve her access to sound. So maybe we try an auditory trainer, personal amplifier, something like that, because she does not obviously have amplification. So maybe we can try some things like that. Put a little amplifying headset on her so she improves. So I'm not shooting down your RTI. I want you to realize that that does apply, because there are some things that can be done that haven't been done in the past. So yes, that's a good idea. As far as transportation goes, well, Ashley, ask your question. What did you ask me about?
So do the laws apply on reservation as they do?
Right, because many laws do not apply on Native American Indian reservations that apply to the rest of us. But when it comes to education, because they are receiving the federal monies, they are covered. So they do apply. But that was a very astute question, and that would be it would make the whole situation moot if they didn't. The question came up about transportation. What do you guys think? Is the district responsible for transportation for medical appointments?
I think I would love to now. I think I would love to now. Yesterday I was speaking in class and she said that they're not allowed to. She used to take people to their appointments and now they're not allowed to.
It varies from district to district, but there's no guideline that requires them, and in some districts and in some states, there's actually provisions to preclude it. We don't know what the specifics are on this reservation, but yes, it's becoming a liability. So they may or may not. However, what are some options for transportation?
A
What-
bus.
Right.
A bus, like public transportation, like, I don't know,
250
Greyhound buses.
miles.
Greyhound buses go
Okay, well,
across the country.
But typically, and I'm not saying this to be racist at all, you can look up the facts yourself, but typically, more than half of the folks who live on Native American Indian reservations live significantly below the poverty line. So having the cash to throw down for a round trip ticket for mom and the child, on a Greyhound, I doubt that the megabus serves the reservation where they might be able to get their ticket for $1. But so using something like that just may not be realistic. What are some other options? There are actually voucher programs. I know when I drop my son off at school every morning, there's a line of taxis. Because there are kids who qualify, their families qualify, because they have medical conditions, what have you, they qualify, behavioral issues, and the family meets the income guidelines. They actually qualify for vouchers to pay for private transportation to and from school. And so and they also pay, they can use that to go to the doctor's appointments. So there may be an option through some of the public assistance programs to get them there. And getting the audiologist there could be an option. The problem is typically the equipment that they need to really do quality comprehensive evaluation probably isn't what they're going to have in Portland. There are portable diagnostic audiometers. I've used them. They're not not the best, but, so that is an option, bringing the audiologist to them. At whose expense, who pays for the testing? Yeah, the school is responsible for covering the expenses, unless they have insurance, like Medicaid, that might cover it. It is going to be on the district's dime, okay? So ideally, what would we like to see happen? We'll deal with the logistics of each step of the way, but ideally, what would we like to see happen then for Eden? What do you guys want to see happen?
Which needs to get evaluation, evaluation for amplification, and then environmental modifications need to be put in place. Maybe with accommodations.
And we're probably going to have an amendment.
Yeah.
Because this really is a change in status when we, we can objectively verify that there is a qualifying hearing loss there. We're operating under that assumption right now, but we really don't have screening from a speech pathologist or tech or someone isn't going to meet that number. It has to be provided by a qualified professional. So, okay, so we want to get her evaluated, we want to figure out what she's going to need. Then we're going to have that IEP amendment. So which laws then are you saying apply in this case? Yeah, clearly that's the primary one at work here. 504 doesn't really apply because she actually does appear to have a qualifying condition. We just have to confirm that. And she's already receiving special services, so we need to modify or adapt the services that she's getting. ADA. We're not really going to know that until we get everything in place and see how she's doing, right? Anything else? Questions, comments, concerns about this case? There's a lot going on. You guys had some very good points that you raised, or some good questions that you had, because there's potentially, what laws apply, which ones don't. I actually got this case from a friend of mine who is a speech pathologist. She used to run an autism program at Cleveland Clinic, Children's Hospital in Cleveland. But before that, she actually was SLP on a Native American Indian reservation in northern Arizona. And the closest audiologist for them was in Flagstaff, which was about 150 miles away. So, and she had a case not identical to this, but similar to it. And so she was asking me all these questions. And I'm asking her a lot of this, well, are they covered by the thing? Do the DOE laws apply? And so, anyway, so we need to get this girl the services she needs some way or another. A lot of times too, culturally on the reservations, if you put the word out that someone needs something, someone's going to provide it. So it may be that a neighbor pitches in and says, I'll take you. You never know. But if we operate solely in the what's required, what's expected, it's a dilemma. Okay. Let's look at case number 4. This is the case of Jack. Jack's a 54-year-old factory worker who has some tinnitus and progressive hearing loss that was gradual onset, and he's having some difficulty communicating. His company does provide equipment to the U.S. Department of Defense. He has a history of unprotected noise exposure during 2 years of military service in his 20s, and he's worked in a variety of noisy jobs through his 20s through his 40s, sometimes not using protection. Sometimes it was because it wasn't practical, sometimes it was because it wasn't always required, and so it was up to them to ask for it. At other times, some of the protective gear that he needed for his ears interfered with his ability to wear protection for his eyes or vice versa, and when it came right down to it, and he had to make a choice, he decided to protect his eyes versus his ears. Seen that happen. He was recently promoted at work, but because he's now spending lots of time in meetings and on the phone, his hearing problems really starting to make it difficult to be effective. So he's filed a workers' comp claim and is requesting hearing aids and assistive technology. But his employer is suggesting that maybe he ought to just go back to his old job if he is quote unquote unable to keep up with the demands of the new position. So, what are the issues at play here? What laws come into effect? What should be done? A couple issues here, so.
Well, we said that he would be, or he should be protected under ADA, and that he couldn't be demoted just because of the hearing loss. And then because they had provided government service, because he works for a company that provides government services, isn't that like an additional protection? And so.
504 would definitely provide him some protection there, because they are receiving federal funding, federal dollars. Yeah.
So if you like needed the assistive devices, that would help him get to that point?
Well, it doesn't necessarily say, that part doesn't address funding. It says they have to comply. So, what law does that apply that I mentioned in this scenario? Workers' comp. Okay, because he has 504 protection, as they're receiving federal dollars, they can't deny him access to necessary services or prevent him from filing a claim with workers' comp. In addition, they can't fire him or demote him simply because he has a hearing problem. They have to document that he is in some way unable to perform adequately. And if it's because of his hearing problem, but there are accommodations that could be made, they gotta make them. So what are some things that they could give him?
Well, if it's in a meeting, you could just have either, I don't know if it doesn't have FM loop, but just something as simple as that, so.
Okay, could be that.
Or if he's on the phone a lot, just an amplified.
Could be an amplified phone might work. You guys have all seen the commercials. Caption
Oh,
phone
caption.
could be a solution. Okay. So they might counter that, we don't owe you hearing aids. You have a long history of noise exposure and hearing issues before you ever came to work for us. So, we're not going to be on the hook for that, but we'd be willing to try caption phone, maybe have, an amplifier in the meeting, something to that effect. What else is at play here? This idea of apply? No, he's over the age of 21, so there's absolutely no application for that whatsoever. So 504 and ADA artwork here. There's also, and we haven't gone into this, and this is not the venue for it, but there are some very specific rules and regulations related to workers' comp that could provide him with additional coverage. And because he was in active duty military, there may be benefits available to him through the VA as well. So the reason I suggest all of this is because if you were involved in this case, you kind of need to be aware of those things. You kind of have to be aware of what are the avenues that you can help steer this person down in getting the services or the accommodations that they need. And unfortunately, like so many things, workers' comp laws vary from state to state. So that you can get assistance through some of the federal programs, which are much more uniformly available and administered, that's great. But I think this is a case where there clearly could be a workers' comp, a legitimate workers' comp issue going on. Another thing that may be helpful, and we haven't really talked about it a whole lot, but we've mentioned in passing, is he may be eligible for assistance and services through the Bureau of Vocational Rehabilitation in his state. And remember, we talked about how in some cases they may fully fund, in some cases it may be partial funding depending on income. So that's another issue that may provide them with some protection or services. Does that make sense? Yes.
Can you think of the Bureau of what?
Vocational rehabilitation. So they provide assistance, training, technology for folks that have disabilities that are impacting them in the workplace or preventing them from actively participating in the workplace. And so here we have a guy who certainly, he's worked, he's working, and now he's at a point where his advancement is in jeopardy because of his condition. That's definitely a case where the Office of Vocational Rehabilitation or the Bureau of Vocational Rehabilitation might provide some assistance. Questions? That was a pretty complicated one too. I promise you I'm not going to give you something that complicated on the exam. If you can navigate through and kind of see the connections in these cases, you'll be fine. I promise I'll make it much straightforward. Okay, so our last one. Case number 5. And it's pretty straightforward. We have Max. He's 2 years and 10 months old, so he's almost 3. Was recently identified with a severe hearing loss following a viral infection. He's been fitted with hearing aids and is followed by an ENT and an audiologist who recommend that he be enrolled in an early intervention program with transition to the local public preschool in order to continue working on his speech and language skills. Mom's contacted the local school district and has submitted to them all of the medical records that substantiate the hearing loss. She's requested that services get started as soon as possible, even though it's now April and the school year is going to be over soon. So under the regulations of IDEA, as we know this is an IDEA case, ideally what should happen and what should be the process that emerges? I should have given this to you guys.
We just said that he needs to enroll in the early intervention program immediately, like being recommended, so he can transition over to IDEA and an IEP when he turns 3, and then determine what an IEP will be, like what district or what services will be provided.
And remember back when we were talking about early intervention, we talked about the Help Me Grow program or the First Steps program. What do they develop in that program that can serve as a transition document when he turns 3?
You think they have like sort of a pre-IEP?
It's an IFSP, the Individualized Family Service Plan. So the early intervention program has to develop an IFSP, an Individualized Family Service Plan, which can serve as a temporary IEP until the transition process is complete. We have 2 problems though. He's 210. We have less than 60 days to get him evaluated and a plan put into place in early intervention. Typically, that process can take up to 90 days. In cases like this, they can typically expedite it, and so having 60 days, but they're basically, when they have their initial IFSP, that initial family service plan meeting, that's also going to be his transition meeting. The school's going to have to send someone there as well so that they will know what the kid's going to need. Okay, what else?
Well, the school is required to transition from early.
Right. So they're gonna basically we're gonna have to get the early intervention folks and the school folks together from day 1 on this case. And so the case manager through the early intervention program is going to be pulling their hair out because that's going to create some real logistical nightmares, but that's no excuse. It has to happen. Okay, so what else? So you said do the transit, get him into the program, do the transition, using the IFSP. Anything else?
Okay, so the school has to cover it if they want private services from another place, that you can request services outside of just what the school provides.
If the school cannot provide it. Because, just because, maybe mom says, that they want services, doesn't mean the school has to pay for it. It would only be if the school is unable to provide it. So, for example, maybe school doesn't have a summer program. Some schools do, some don't. Maybe they don't have a summer program. So, the parents could request, and the school may or may not approve it. I know when I was working for Easter Seals, we had a summer therapy program that ran for 6 weeks, and Boone County Public Schools paid for students to come to that program because it really, in the long run, saved them money because the kids didn't regress over the summer, and the school may or may not agree to something like that. And because this kid really critically needs the services, and it's at the end of the school year, if they don't provide a summer program, and they may, we don't know, but if they don't, they may. So yeah, that's definitely something parents could request. Does 504 come into play here? Well, but he qualifies for an IEP, so it's really one of those where it would just provide them with further protection. If the school balked at anything, the parents could probably invoke their rights under 504 and really push the issue. But most school districts, particularly with kids with a condition like hearing impairment, they're not going to balk. Parents are mom's not asking for anything unreasonable. And ADA, really, because there's no discrimination going until and unless we know what they're gonna provide. So this is one where that's why I just went ahead and said, not a good idea, because it really is the main one that's going on. Questions? Was it helpful to work through these scenarios so you can kind of get a feel for, it's complicated. It's not easy. I appreciate that. I understand that. And you're going to have questions. Keep your notes, keep your slides, keep your information. Know that laws are always changing, and so what applies today may not apply 3 years from now when you're starting out in your career, or 5 weeks from now when you're starting out in your career. But hopefully the laws aren't going to change that quickly. But know that there are resources out there, but it's not going to be something that you can just go into it and do it on control. It's on autopilot. We're going to have to really go through this step by step. All right, have a great weekend.